Good afternoon, everybody. Welcome back in the meeting, reviewing the report of the government. We will first deal with the follow-up questions that were presented before the lunch break. Then we will move to the cluster 4 and 5, which are on civil rights and freedoms, and family environment and alternative care, which are a round of questions and answers. And then we will move, after a short break, to the cluster number 6, that is on health and welfare. So the floor is to the head of the delegation, Madam.
Good afternoon, dear colleagues. This morning, there are a few remaining questions that we would like to answer now. First of all, in response to Professor Kopp's question about the best interest of the child in adoptions, whether adoptions can be terminated one-sidedly, the Social and Family Affairs Administration would like to answer the question. Please. Thank you. According to our civil code, in adoption or the termination of adoption, approval must be obtained from the court. So there's no way that one parent can terminate adoption, and the court will also take into account the best interests of the child in making these decisions. We also have a copy of the relevant provisions in the civil code for your review. Of course, there are certain exceptions. For example, where there is an incident of abandonment or there's severe disability. In that case, upon the request of the applicant, the court may make a decision to terminate an adoption. So there are rules and regulations in place to govern these matters. Social workers are also involved to tap into the views of the adoptee children. I will leave it there. Thank you. Please. Chair, distinguished members of the committee, good afternoon. On the termination of adoptions, when it comes to the right of the child to express their views, there are no laws indicating at what age the child can express their views. So as long as the child is able to express his or her ideas, he can exercise this right. The court and the stakeholders, professionals also will ask views and opinions from the children concerned. The lawyers, teachers, and parents, whether or not they have been trained in this regard. For example, parents or teachers or lawyers accompanying the child in the court proceedings. Before the session begins, a social worker will help provide such counseling services. If the social worker determines that it is necessary for the lawyer, the parent, or the teacher to receive such prior training, then an appointment can be made beforehand. So these parties concerned can go to the social worker's office for an interview and some training. The social worker will then use that opportunity to explain what these parties should pay attention to in the court. For example, who will be present in that court session and what roles or functions those present in the court session have. the parents or teachers will also be reminded by the social worker what they should be aware of when the child is expressing his views. For example, some parents and children may not be so clear about what they can say in the court. In that case, they can seek advice from the social workers, and social workers can provide counseling assistance to teachers, parents, and lawyers accompany children in the court. In the court session, all parties will try to listen to all the child's views as much as possible. Thank you. Next, in response to Professor Kopp's question on education and training, whether or not there are mechanisms to narrow the gap between the budgets for the rural and urban areas, and when a child lives in a dormitory, are there any mechanisms to oversee their safety? Teaching staff in rural areas, are there plans or measures to reduce the number of substitute teachers in these schools? Are there national procedures in place to handle complaints filed by students? On indigenous students' education in their ethnic languages, the Council of Indigenous Peoples can answer that question. The Ministry of Education, please go ahead. This morning, I already mentioned that the Ministry of Education has different allocations of budgets for rural and urban areas. One type is so-called general subsidies for teachers' salary, or the lunch meals subsidies for students. And we do have an evaluation mechanism for the use of such general subsidies. We do have key performance indicators to evaluate whether the city or local government has used the budgets effectively. The central government will determine the next year's subsidies for the city government based on the evaluation results. In addition, there's a so-called ad hoc or project-based subsidies. These are project-based subsidies which would come with responding counseling programs. These counseling programs will help the city and local governments to use the additional subsidies effectively. For example, improving the learning results of their students. So more attention will be placed on providing assistance and counseling to city and local governments rather than as a basis for performance evaluation. As for the substitute teachers in rural schools, it is true that because these schools are located in offshore islands or remote areas, there tend to be higher proportion of teachers in those schools that are sub-teachers, but sub-teachers are still qualified teachers. It's just because there are fewer classes of students in rural schools. They cannot afford to hire as many full-time teachers. That's why they have this practice of hiring substitute teachers. How do we reduce the number of sub-teachers in rural schools? We do have a guidelines for providing grants to schools that try to reduce the number of substitute teachers. And actually, this year, we offered grants to 3,000 sub-teachers in elementary schools in rural areas. We also provided grants for 1,000 teachers at middle school in rural areas. So we do have additional subsidies for teachers in rural areas. Every year, the budget is 2.1 billion Taiwan dollars. As for the merger of smaller schools in rural areas, when it comes to grade 1 to 9 education, this is in the purview of local governments. Some local governments, due to cost concerns, may be keen to combine several schools together. That's why the Ministry of Education has a guidelines on these matters. Local governments in combining teachers will have to follow the guidelines, and specific procedures and criteria have to be met. For example, if a school is to be phased out or combined with another school, specific assessment has to be made. Public hearing also has to be conducted to hear local people's views. And the local government's education committee also has to review the whole process. And that particular education committee comprises of experts on education, parents' representatives, and local government officials. Also, according to the guidelines, local or city governments in making these proposals will have to come up with a so-called autonomous operation method for the new entity. So even though these matters are in the purview of local governments, the central government has some oversight mechanisms in place to prevent local governments from closing schools because of budgetary constraints. On the other hand, for some schools in rural areas, we may prohibit the close of certain schools. For example, if there's only one middle school or one elementary school in one town or one city, they shall not be combined with other schools. Or if there are concerns about students commuting to their schools from their neighborhood, then no close of schools or combination of schools will be allowed. As for the budget for indigenous communities or the indigenous students and their education in their mother tongue, right now in elementary schools, Hakka, Taiwanese dialects, along with different ethnic languages, are combined into one subject. Every year, we have 200 million Taiwan dollars budget for these education programs. The money is used to support the promotion of education in mother tongues. In fact, many Aboriginal communities have their local schools that will be in charge of these programs, and the money will also be used to promote the development of teaching materials. The ministry's stance is, as long as the students want to choose the subject or the subject of their mother tongue, no matter how few students there are, the ministry will try to provide as much support as possible. So as long as the students want to learn their ethnic or mother tongue, we will render as much support as we can. As for the complaints mechanism, we do have a students' complaints assessment committee. If a student is disciplined by his schools and he finds it unfair, he can file complaints to that committee, and the committee will submit that complaint to the city or county level committee for these matters. We are proactively setting up these other mechanisms. For example, you can write letters to the Minister of Education. And also, we do have regulations concerning the rights of students working in factories as part of their collaboration education program. They also can file complaints through the judicial branch.
I would
like to add some more information to mother tongue education for indigenous students. I'm from the Council of Indigenous Peoples, CIP. In order to help students to learn about their mother tongues, we have a 6-year program which lasts from 2014 to 2019. We provide subsidies to preschools, and we organize some camps for indigenous students to experience indigenous lives. And the program is also used to support church in indigenous communities. Thank you. Professor Landy asked about children with disabilities, and the number of such students appear to be increasing in institutions. Why is the reason? Representative for Social and Family Affairs Administration will respond to this question. Well, there's a history of the development of such institutions in Taiwan. In earlier times in Taiwan, most of such children were taken care of by such institutions. However, in recent years, we realized that there are not enough resources in communities. So we are planning to invest more resources so that children can remain in their households, in their home, and will send extra help from the communities to help them. We want these children to be integrated as part of the community. So currently, we're working hard to investing those resources. So we have a 5-year program to roll out this policy. When there are more and more resources in such communities, I believe that the number of children in institutions will decrease. This is what we are working on right now. Next, Professor Tobin asked about suicide of teenagers, children, and youth, and their disaggregated data regarding their sexual orientation and so on. Well, earlier in the morning, we have more data, more disaggregated data for attempted suicide. Every year, there are about 30,000 children and youth attempted suicide and are reported to our system. In the morning, I mentioned that the common cause, the most common cause is relationship. That's why most of the children and youth attempted suicide, according to our data. But we do not have disaggregated data for LGBT population. So we do lack that kind of data. Maybe in the future, we can conduct some investigation survey first before we design our questionnaire or data collection method. Thank you. Professor Tobin also asked about best interest of a child, but I think part of that answer was part of the question was answered already. But we already provide the translation of Article 1055-1 in Civil Code. As for any training provided to parents, teachers, or lawyers who should teach students to express themselves? Oh, has this been answered? Okay, it has. So let's move on to the next question. The next question is how stateless children can be naturalized if they are under 18. Maybe the Ministry of Interior Affairs can respond to this question. Anyone from the Ministry of Interior Affairs? Hi, I'm from the Household Administration of MOI. I think Mr. Chair asked if a stateless child is under 18 years old, he or she has not yet been adopted. Well, according to the current Nationality Act, if they're not adopted, what happened to them? Because if they're adopted, they can be naturalized. But if you have not been adopted, what happened to them? Well, in August 2017, the Ministry of Interior's policy. Well, since that time, our policy is that when the government is a guardian of this stateless child, then these government agency, the social affairs agency, will file for naturalization of this child on behalf of this child who has not yet reached 18 years old. Okay, all right. I think this round of the answers has been completed, Mr. Chair. 进入下几个章节之前，我想要针对司法跟法官再问一下问题。孩子会在有社工、父母、老师的陪伴之下，私底下跟法官表达他们的意见吗？我觉得这个做法蛮重要的，因为如果是一个儿少的话，儿少可能面对有很多成人在他身边的时候，他可能不太敢说话。所以我的问题是说呢，法官会不会私底下见这个孩子，听取他们的意见？
谢谢。
Anyone? Thank you very much for the question. When children are in court and when the court deem necessary, indeed, judges will separate the child away from the family members or other adults because the judges are worried that maybe the child will suffer too much pressure from the family or be led by the family as to what they say. So when the court think it's necessary, the court will ask the separation between the child and the family members. But when doing so, we still ask social workers to accompany the children so that children feel less nervous, and it helps to stabilize the psychological status of children. And social workers can help children express their opinions if it's necessary. Thank you.
Thank you very much for the answer. It's clear. I have done a lot of those cases, and there are children who tell you, I don't need a social worker. I want to talk to you alone. So that is also a possibility. But that's the practice, and it's very important when we talk about rules of the convention that we try to get a good picture of what is happening on the ground in practice. So we continue with questions on issues that also can have interesting aspects when it comes to the practice of implementing. We have first civil rights and freedoms, and I'll give the floor to Ms. Lundy first.
Good afternoon, everyone. You'll be happy to know that I have very few questions in this head of civil and political rights, and I think that's a sign of a very healthy and open democracy. And we saw that in action yesterday with your NGOs, that there are fewer questions here than there may be in other places. almost all of the issues that arose for us in civil and political rights related to children in schools. So the issues that are being raised are generally seem to be happening in schools. And children were telling us in their reports and yesterday concerns about things like privacy, that even though there are laws saying that they can't be searched, their bags can't be searched except for very particular reasons, they are being searched not for those reasons, just to check if they've got phones. There's concerns obviously about corporal punishment, but we'll come back to that. A very general concern about freedom of expression. And even though there are institutions set up in schools, like the School Affairs Committee, children and young people are very concerned about how comfortable and safe they feel complaining in those contexts. So they said to us, if there are only 4 of them in a group of 48, that actually that is not a comfortable space for raising issues often, and they worry about repercussions. More generally, there's an issue. We had raised the issue of the ability to form associations being restricted to 20, so I'm going to leave that. But in terms of freedom of assembly, children's freedom to get together, to form groups, to protest, there were concerns about what would happen to them and what in fact has happened to some children when they try to do that. And in fact, there have been some very heavy-handed responses from teachers and schools. And our questions really then are how they complain. We know there are complaints mechanisms, but again, children are saying that often when the people they complain to may include the teachers themselves who they want to complain about. And I suppose that really reinforces our very first point today about an independent, accessible complaints mechanism outside the school. But the question for now is what the sanctions would be for teachers who are breaching these rules in schools. Does it come up? Is there an independent inspection process? Is this one of the issues that they inspect? Children's freedom of expression, freedom of assembly, privacy? Is that an issue for them? And what happens to teachers who break these laws? A related issue that came up was a question over the use of military training officers in schools. So some children were complaining about the fact that people from outside the school, from military training schools, were brought in to impose discipline. And that was felt to be unfair, overly harsh and inappropriate. So the question is, does this happen? Are there rules and guidance on this given out to schools? And those are my main questions related to civil and political rights in schools. There was a question I asked yesterday, and again, it may be not an issue, but I want to ask it anyway. And that is the issue of freedom of conscience. I'm just wondering, for children who come from minority faith positions, what are the protections for them, and what do you see perhaps as some of the issues that they may face, and what is happening to address any of those? Those are my questions.
Thank you, Mrs. Lundy. Mrs. Karp?
I remember. My question is, when you are outsourcing children's services to private institutions, is it a condition under this outsourcing that the institution knows about children's rights and they are responsible to give children's rights who are under their 40? My next question is, I would like to go back to what we've been told. The children may complain before the courts. And my question is, how come, if they don't have any legal status before the courts, how come that they can complain? And the next question is, children are not aware, or they need to really know what is. I know that under the law, corporal punishment, for instance, is illegal, but the definition of measures that infringe on children's rights are not defined generally, nationally, by a legislation. And the question is whether you intend to elaborate, to give children to understand what are real bases for complaints for them. Not to speak about the fact that they are afraid to complain because the complaint committee, the first complaint committee consists of mainly of teachers. And the representative of children is not really effective. His presentation. I didn't hear the answer on the control protection of children in the dormitories in case of merger of schools. And my last question is try to demonstrate. We have heard a case that children, rather a famous case, children were demonstrating in the Ministry of Justice about the curriculum. And they were dealt by the police, which handcuffed them, took them to the police. My question is Control Yuan has to deal with such cases? It was, I think it was published in newspapers and it's just one example to understand what are the cases that the Control Yuan deals with. Thank you.
Thank you, Judith. Mr. Catwell. Family environment and alternative care, I just no. On this section, I'd like to pose a question again, another question on the issue of stateless children and some questions in relation to disciplinary measures in institutions. So my question in relation to stateless children may have been answered already by the representative of the Ministry of the Interior, but who mentioned the fact that as a result of the decision in August this year, I think, that applications for naturalization would be made on behalf of those children who had not been adopted, etc., would be made on behalf of those children. Would those children include the children of foreign mothers who give birth here and then leave their child? And those children are currently not, as far as I understand it, eligible for naturalization because the mother is known and is a foreign national, and although the father would be a Taiwanese probably, but unknown. So the fact that the mother is known prevents and is foreign prevents the child from being naturalized. Is my understanding correct? And is the situation of such a child covered by the kind of measure that now has been described by the Ministry of the Interior? Moving to the slightly different issue of disciplinary measures in institutions, I'm a little confused by the written response to the list of issues that we gave. Excuse me for going into detail, but I think it's necessary to do so. In the responses, in relation to solitary confinement, the possible use of solitary confinement in institutions, it was said that solitary confinement is not a form of punishment used in juvenile reformatory schools or in reform schools, but in the same paragraph it was said that if there are serious violations of discipline in a juvenile reformatory school, a child may be placed in a solitary room for a maximum of 5 days, and in a reform school that maximum could be 7 days. So I'm not clear what the situation is. Either solitary confinement is not used as a punishment, or it is used as a punishment in severe cases, but it can't be both. And in juvenile detention homes, it is not used. It was the response we got. Also, in reform schools, but not elsewhere apparently, there can be a ban on visitors or visits for a maximum of 3 times in response to serious disciplinary behavior. Now, solitary confinement and a reduction of visits, and particularly family visits, are not in conformity with, in particular, the UN rules on the protection of juveniles deprived of their liberty. And I would really like to know whether or not these forms of punishment are effectively used here. Now, there may be a logic in the differentiation between the use of such measures in the different types of reform schools, reformatories, detention houses, but we would need to know what that logic is. And given that in those institutions it would seem that there is a provision for using those forms of disciplinary measure, I'd also like to be reassured or informed about the use of such measures in protective environments, in residential care institutions. And then there's the additional issue of the use of restraints. Now, in the response to our list of questions, it was said that there are punishments that are foreseen for staff who abuse the use of physical restraint, physical punishments. But there was no indication of whether or not physical restraints are allowed, and if so, under what conditions. Now, the use of physical restraints in itself is not a violation of the rights of the child to the extent that the use of restraints is indeed governed by strict regulations and strict criteria as to when it may be appropriate and what degree of restraint might be used. So I'd like clarification on the regulations surrounding the use of restraints in institutions, and in particular in detention facilities. Thank you. Thank you. Mr. Tobin.
I have 2 brief questions in relation to the issue of statelessness. Number 1, do we have any current data on the number of children who are in fact stateless? And number 2, In the NGO reports, there's been a suggestion of a need for a statelessness determination procedure. I'm keen to see what members of the government think about the need for that procedure. Thank you.
Thank you. I open the floor for answers to the question, because we can continue with the family environment and alternative care, but that is quite a huge topic. So it would be better, I think, for you to first answer the questions on the civil rights and freedoms. You have the floor.
First of all, in response to Professor Lundy's question on the student's right to freedom, association, assembly, and privacy, as well as the right to file complaints and the freedom of conscience, especially among minority students, the Ministry of Education has the floor. Yes, the Ministry of Education, in safeguarding students' rights, has an education act. According to the act, the students are at the heart of all education programs and systems, and there should be no discrimination against students based on whatever reason. According to the provisions in that act, disciplinary actions, counseling services provided by teachers in schools must safeguard the students' right to freedom of expression, freedom of assembly, and association, as well as the right to personal development. So these are all clearly spelled out in our guidelines for counseling and disciplinary methods. In addition, for all schools that are setting policies for methods of counseling and discipline, the interest of the students and children must be safeguarded. That is why there are complaints mechanisms. So these are all proactive measures we take to safeguard students' interests. But of course, if teachers violate such rules and policies, what sanctions are there? According to the Teachers Act, there are specific provisions saying that in the case where teachers violate these provisions, causing harm to the mental and physical health of the students, the schools disciplinary committee can fire the teacher. As for corporal punishment in schools, in Taiwan, corporal punishment is defined not only in terms of physical harm inflicted upon the student, but also includes verbal, bully, inadequate disciplinary actions taken by teachers. Also, as local governments, there are also assessment committees in place to assess whether or not certain teachers and their actions are appropriate. If some teachers' actions have caused harm to their students, then that committee can review the case and impose sanctions accordingly. And from elementary school to senior high schools, counseling offices are set up in all different levels of schools. For example, some students are very shy. They are not brave enough to speak up or to file complaints for themselves. The counseling mechanisms in schools can play some role. For example, there are some parents who work as volunteers in schools. There are also suggestion boxes inside schools, or counselors can come to their assistance. As for the rules concerning the role of military training instructors. In old times, these instructors were recruited to help for improving campus security and safety. But then it has been decided that starting 2021, these instructors will phase out of campus. In the future, professionally trained innovative counselors will then replace the roles played by these military training instructors. So we believe the introduction of the new staff into campus will help us to provide better counseling services to students. In 2014, there was an incident involving students protesting to and at the Ministry of Education. The former administration engaged in some black box decision-making regarding the curriculum guidelines, thus invoking protests from the students. But when it comes to the curriculum, new curriculum guidelines starting to be effective in 2019, the existing administration has adopted an open approach, inviting student representatives. As for the number you said, 4 out of 48 members of the committee are students. But that is just one case involving the review of the curriculum guidelines. However, if you look at the subgroups, you will see for each subgroup, at least 2 student representatives are present in these subgroup meetings. In other words, students do have a full say as to what they want to study or learn in different subjects at schools. So the curriculum guidelines review process is very transparent for everyone's review. Thank you. Regarding the protest at the Ministry of Education, maybe the Control Yuan would like to provide additional information. The curriculum guidelines, yes, in 2014, the Control Yuan conducted an investigation. The result shows that there were some procedural problems, and the investigation reports were also publicized. However, we did not receive any complaints from the students' side about that incident. Well, in addition to that, Madam Kopp also talked about when you outsource services to private institutions, is the knowledge of CRC a prerequisite for such contracts? Yes, when it comes to the training of CRC knowledge, yes, these vendors or providers of services are also included. For example, they can leverage the CRC teaching materials developed by the central government to learn more about the CRC. So the central government does have this requirement. How do we oversee this? In performance evaluation, we do take this into account. So this is a requirement we impose upon local governments.
I think Professor Kopp also asked about the legal capacity of children who are in legal proceedings and the definition of corporate punishments and the appropriate management in dorms. Would MOEs continue to respond to those questions? Corporate punishment is not only physical. Corporate punishments also includes mental or abuse or verbal behavior anything that hurt the child physically or mentally or psychologically is considered to be corporate punishment. As for dorm management, in fact, if there's a dormitory in some schools, usually there are life counselors for students. And these life counselors are hired by the government, or they work for the government on the contract basis. So they'd have to follow the rules which apply to public employees. So if they apply corporate punishments or mismanagement to the students, then they are subject to the Public Employees Act, and they will be punished under those acts accordingly. And Professor Conwell asked about stateless children. So the mother made from a different country, and it seems that there are some limitations to help those stateless child. And Professor Tobin also asked about the number of stateless child and status procedure. MOE, please respond. If the father or the mother of this child is a foreign national, and can't the procedure I talk about, which has been effective since August this year, the household administration would like to make the following explanation. Well, according to Nationality Act, Taiwan use jus sanguinis, right of blood, and we also use jus soli as a supplementary rule. So if one of the parents is Taiwanese national, then this child is considered to be Taiwanese and has such nationality. But if the parents of this child are unknown, and if the nationalities of the parents are foreign, but they are born, the children are born in Taiwan, they can consider to be Taiwanese. And adopters may adopt these children, or the social affairs agency may submit application to naturalize these children on behalf of these stateless children. Now, if the mother is a foreign national and she gave birth of a child in Taiwan, there could be 4 possibilities according to Nationality Act. The first scenario, the mother is foreign, but the father is Taiwanese, and the child is acknowledged by the father. Then, according to the Household Registration Act, this child will be registered as a person with a nationality. Second scenario, the mother is foreign, father is also foreign or father unknown. Because we mainly use jus sanguinis and use jus soli as a supplementary rule, so this child does not have Taiwanese nationality. The third scenario, both parents are unknown. Then, according to Nationality Act, this child is entitled to Taiwanese nationality. He or she doesn't have to be naturalized. In the fourth scenario, well, in January this year, in order to implement CRC and protect the best interest of child, there has been a special measure. So the mother is foreign, and the mother has a return to her homeland, and the father is unknown. Then with the foreign embassy's help, and or we may make inquiry to the government of the mother's original nation, and the foreign government told us that, this child is not registered as our national, or the foreign government does not respond to our inquiry within 3 months. that according to Article 3 in the Nationality Act implementation rules, we consider this child to be stateless. After this consideration, then, according to Article 3 of Nationality Act, this child can be naturalized through different ways. First of all, he or she can be adopted, and the adopters will file for naturalization. And if this child reaches the age of 20, he or she can apply for such a naturalization on their own. And if this child is not adopted, and he or she is not he or she is under 20, then Social Affairs Agency will file for naturalization. Immigration Agency would like to add by saying that if children are born in Taiwan, and in fact in June we have a new policy, a new status procedure. There's a procedure guideline that has been newly issued. For such a child who is born in Taiwan, who before he or she is considered to be stateless, we will check the nationality of the mother and see if we want to issue a foreign or to issue a residential certificate to this child. After that, we will work to look for the mother. If the mother has left Taiwan, then we ask the Ministry of Foreign Affairs to send inquiry to the original, to the government of the original country. If within 3 months there's no response and we're not able to locate the mother, then we identify this child as stateless. Currently, there are 233 cases like this. 57 cases have been addressed. 174 cases are still ongoing. We're still looking for the mothers. But during this time, we issue the residential certificate to these temporarily stateless children so that they are entitled to relevant services or benefits. That if they're considered to be stateless, they can be adopted or they can go over other procedures to be naturalized. Thank you. Next, maybe MOJ. Please respond to restraints or violence used in institution as behavior management. As for solitary confinement, is it used as a disciplinary action? Well, there are correctional schools, reformatory schools, and detention centers. And detention centers accommodate children who are under protective detention. And the other 2 schools also accommodate children with different status. So children with different situations are protected under different laws. In our law, solitary confinement and restraints are forbid to be used to manage students' behavior. If there's violations, then we will ask prosecutors or police officers to investigate the case. And in case of solitary confinement, usually because the youth are very aggressive, of the children have infectious diseases. That's the only time restraints may be used. But in that case, we arrange doctors or the counselors to help the students. We do not bereave the children of the right of contacting or having contact with the other people. And in such institutions, the youth or children can still write letters to their family members, and we organize activities for family members and the children to get together. Thank you. Any agency which would like to supplement information? Okay, no, thank you.
Brief follow-up from members of the committee. Your microphone. Your microphone.
I'm well aware that the laws and regulations protecting civil rights of children are in place, and they are very promising with regard to the approach. The question is, what is the reality, and how really the institutions, schools, really implement these regulations? And my question is whether the Ministry of Education have a national monitoring system to see whether these rules and laws and regulations are implemented properly. For instance, we are in the list of questions we asked how many teachers have been punished in the last 3 or 5 years, and the answer shows that very few teachers were. So maybe there is a gap between the good intentions of how children are treated in school and institution, and between the reality of life and the implementation. Connected to this question is why is the role of the local authorities to deal with infringements of the right of children in school? Why isn't it a national problem of the Ministry of Education to see that all regulation and the laws are really implemented? There may be difference between the local authorities about how they see the true implementation of the laws and regulation. And I think it should be a nationwide attitude with regard to these questions. Thank you.
Other members with follow-up questions? Yes.
So, if I understand, in terms of the use of solitary confinement within the reform schools and reformatory schools, and I understand the different status, within those schools, solitary confinement is not used as a punishment, but as a behavioral management measure. Is that correct? And that would explain that in your response to our questions, you had said these institutions do not use solitary confinement as forms of punishment. An offender may be confined to solitary room if he or she has if a very serious violation of the disciplinary rules has been committed. So it would be a question of, I think, possibly one of interpretation in that case as to the issue of behaviour management or punishment. But I'm still a little confused, I have to say, on the actual use of solitary confinement.
Just in addition to this question, if it is not a punishment and the child is in a solitary room or solitary confinement as a measure of behavior control, but also in terms of behavior treatment, what happens to that particular child in terms of counseling, treatment, discussing how to improve behavior. Is that part of that measure, or is the child left to her or his own just for 5 days or 3 days, except for some contact over food? Okay, that were the supplementary questions.
委员刚刚提到教育部的
Regarding the question about the national mechanism of oversight, and if there's any inconsistency between the central government and local government, why are there so few teachers that have been punished in the past 3 to 5 years? Well, in our system of recruiting teachers, I would like to offer you some background information. In elementary school and middle school, in other words, students under the age of 15, their right to education falls into the purview of local governments. The same goes for the management of teachers in those schools. If a teacher violates the rules regarding student discipline, then teacher discipline committee will be able to make a final decision whether or not the teacher should be fired or be suspended from his duties. If the student is not happy with the result of the committee, he can go on and file complaints. On the other hand, the local government may take an initiative to investigate into matters or receives complaints from parents about misconduct by teachers. The local government also has a counseling group as well as the advisory committee to look into the qualifications of the teacher, whether or not he is suitable to teach. And for national, senior high school, or universities, students in these institutions tend to be older. Therefore, there are fewer cases where the teacher needs to engage in severe disciplinary measures. Also, starting 1999, our law already says it very clearly that no corporate punishment is allowed. And since 2007, the Ministry of Education has been promoting the zero corporate punishment policy on campus. Any teacher using corporate punishment will be facing demerit treatment. Under the new policy, in elementary schools or middle schools, things have improved tremendously compared to 10 years ago. Especially, we have such low birth rate. Each class has only 20 or even fewer students. As a result, the teacher can be very friendly in providing counseling assistance to his or her students. We also have a Student Counseling Assistance Act for schools with a specific number of classes are required to set up counseling offices where counseling teachers are present to provide assistance to students. And if the students feel they have been bullied or wronged at schools, they can seek help from these counselors. Next, Ministry of Justice. Please answer the questions from our chair and committee members concerning the solitary confinement and the relevant regulations in reformatory schools and correction institutions. Okay. At correctional institutions, we take the issue of solitary confinement very seriously. it is only with very serious violation of the disciplinary rules of the group life will the resident be facing such solitary confinement, and they must not be longer than, say, 5 days or 7 days. There are some exceptions. For example, if the juvenile has infectious or communicative diseases, we need to isolate him or her for the sake of protecting himself and the other juveniles at the institutions. Or if the juvenile in question is very aggressive, we need to protect himself as well as other juveniles of the institution. During the 5-day solitary confinement, the counseling teachers and other teaching staff will also intervene based on the juvenile's individual needs. We also have counselors with religious background providing assistance to these juveniles. Anyone would like to provide additional information? No? Thank you. Then that's all.
Thank you, Minister, for this round of answers. I think we can move to the next cluster, which is the one on family environment and alternative care. And the floor is to Mr. Cantwell first.
Thank you. My questions will relate to alternative care and adoption in particular. So on the question of alternative care, and particularly in relation to the prevention of the need to consider alternative care for a child, I'd like to ask what forms of financial support are available under what conditions to families at risk. And I ask that question because we heard yesterday from civil society that there were concerns about the degree of restrictiveness in relation to accessing financial help. Now, they also mentioned that that families in poverty were not necessarily at risk of losing their children, of having their children removed, but nonetheless, in high-risk situations, we need to be clear about the right of families to try to access financial and possibly other assistance in relation to their ability to care for their children. So what are the conditions under which a family can access supplementary assistance? In relation to, let's say, the three major forms of alternative care, we note that kinship care, foster care, and residential care are the three forms prevalent not only in Taiwan but in much of the world, and that priority is given in principle to kinship care, followed by foster care, followed by residential care, which is very fine. In relation to kinship care, it appears from the information we have that kinship care is actually not promoted very actively, and that kinship carers are subjected to considerable conditions or criteria for selection, if you wish, in terms of formalizing any care relationship they may have with the child. So the question will be, to what extent are the criteria, or rather, what are the criteria that are used for determining whether or not a child can remain in kinship care, and is that that situation a brake? Does it act as a brake on the ability of children to remain within their extended family instead of being sent to a foster family or a residential care facility? In relation to foster care, it seems that there, from the statistics provided, that there are a gradually increasing number of foster parents, foster households, but that the number of children being fostered is going down slightly. And I wonder if that is a result of longer stays or other factors, and it would be good to know what the situation in relation to foster care is. Is recruitment difficult? Are foster parents sufficiently subsidized? Do they receive allowances, sufficient allowances to enable foster care to be a viable solution for those children for whom it may be appropriate? Now, in relation to residential care, this is a little bit more complicated. What we can see apparently from the figures is that the number of children who are in residential care is falling slightly overall over time, but that the number of service providers, and particularly private service providers in that field, is growing. Not exponentially, but nonetheless is increasing. Now, it would seem that the occupancy rates in public facilities are relatively high, whereas overall in private facilities the occupancy rate is falling. If that's the case, the question would be, why is the state licensing more private facilities at a time when the number of children accessing those facilities is, I would say, thankfully, declining? Does that not create a situation of overcapacity, which in other circumstances, or rather in other countries, has, for example, led to the unnecessary recruitment almost of children into institutions, particularly private institutions that may be dependent on subsidies that are calculated by the number of children who are being looked after. So that is one question. Another question is that we received conflicting information over the extent to which the quality of services provided in private residential facilities is monitored. On the one hand, there was the opinion that there is over-regulation of private facilities. On the other hand, we received the opinion that the local authorities which are responsible for monitoring such facilities are in fact not implementing the monitoring powers that they have. So I'd appreciate very much the opinion of the government in relation to that. Is the regulation of private facilities ensuring that they are providing adequate, or I would say more than adequate, services to the children? Is that being monitored effectively? And another aspect was that, or another part of the information we received was that private facilities are underfunded, are not funded in a stable manner, which does not enable them to take on qualified staff, to retain qualified staff, and therefore to provide a level of service that would be appropriate for the children concerned. And in that relation, it was noted that children with disabilities or children with behavioral difficulties are often refused admission to private facilities because they do not have the qualified staff to cater to the needs of those children. Now, if the underfunding is correct, yet the number of places in private facilities is growing, then there would seem to be a slight disconnect between the needs in the sector and the actual provision of residential care services. And a final question on alternative care is the question of leaving care. We received information that children are obliged to leave the formal alternative care system at the age of 15. First of all, we'd like to know if that is correct information, because it surprises very, very much. Is that information correct, that children have to leave alternative care at the age of 15? Secondly, what preparations are made for those children at whatever age? What preparations are made for them leaving care? This is for leaving care and in the post-care period. This is a really important question, not only, again, in Taiwan, but worldwide. The issue of ensuring that children who leave care are prepared for life in the community and supported in their independent living as needed once they have left the care environment. So, two questions there. Is it age 15 that everybody has to leave care? And secondly, what are the circumstances under which they actually leave care? Now I'd like to move to the issue of adoption. And again, it's quite a complicated situation, but perhaps less so than in relation to alternative care. What we seem to see from the data provided is that in Taiwan there are approximately 125 to 150 domestic adoptions per year in recent years. And many of these, as far as I can understand, are intrafamilial adoptions or adoptions by a step-parent. So 125 to 150. Inter-country adoptions from Taiwan are between 160 to 200. So considerably, or at least significantly, higher than the number of domestic adoptions. But at the same time, you have, on average, some 60 or 65 children being adopted from abroad into Taiwan, and notably from Vietnam. We would like to know what's behind those figures. Why are domestic adoptions so low when Taiwanese, apparently Taiwanese, maybe this is something to be cleared up, but apparently Taiwanese are adopting from abroad. So why are domestic adoptions so low in that kind of circumstance? And why are children being both adopted in Taiwan and being sent for adoption from Taiwan in not dissimilar numbers? There we're thinking in terms, of course, of the need for the priorities to be established between domestic adoption and inter-country adoption, where inter-country adoption is subsidiary and should only be considered if there are no domestic solutions for the child. Which means, in this case, in particular, not only, but in particular, the domestic adoption of the child. And then, finally, to come back to, in a way, to alternative care, but it also has an effect on adoptions. We don't see an overall strategy in terms of alternative care. We see progress being made in certain areas. We see less progress in others, but we don't see a full strategy in relation to the provision of and the use of alternative care in Taiwan. We don't see either any reference to the UN guidelines for the alternative care of children, which were adopted in 2009 and which give a comprehensive overview of the approaches, policies, programs that need to be taken into account when providing alternative care. And in particular, they require, or they suggest very strongly, because they're not a binding instrument, but they suggest very strongly that every state draws up a strategy for deinstitutionalizing its care system. In other words, reducing the reliance on residential institutions to provide alternative care and substituting that with family-based care or a better program for preventing the need for children coming into care, or both at the same time, in fact, so that the reliance on residential care is reduced. Now, de facto, one could say almost that there is, since there is a reduction in the number of children apparently coming into residential care, then we're already on the right road. But we don't see an overall strategy to ensure that residential care becomes a rare phenomenon, a rare measure, used only when it is specifically for the benefit, or rather specifically a positive response, a constructive response to the needs of a child that could not be better met in a family environment, in a foster family or in kinship care. And we need to know whether the government is looking at drawing up a strategy to deinstitutionalize the system, particularly because at the moment the number of institutions is actually going up. I'm sorry I was so long, but there were a lot of questions raised by the responses that came to our list of questions. Thank you.
Thank you, Mr. Cantwell. Mr. Tobin. Okay. Go ahead.
Thank you. Speaking about families, I would like to raise the question whether corporal punishment by parents is unlawful, or I couldn't make, I didn't understand exactly. I think that serious abuse is prohibited, and the question is, what does it mean, serious abuse? And connected to this is the question of if you have the system of protection orders in order to remove the perpetrator instead of taking the child, the abused child, to an institution or out of the family. My next question relates to same-sex families. So I understand there was a pronouncement of the Constitutional Court that the Civil Code excluding same parents legally marrying is unconstitutional, and I understand that there is now the legislation to settle the rights of same-sex parents towards their children, and it's going together with the amendment on the age of marriage, and it may hinder the finalizing of the amendment for the age of marriage. My question is, in reality, and until the amendment goes through, what is being made to guarantees that parents of same-sex families have equal rights to parents from families, other families, like the question of whether both of the parents have a guardianship over the children or only one of the parents have a guardianship. What is there in the amendment? What are the details of the amendment to regulate the same-sex marriages? Thank you.
Yes.
Again, just one brief question. I'm curious about family education. How much is spent on family education, and what are the things that are topics that are covered in family education, and which parents get it?
Thank you. A question on children in alternative care and the return of those children to their quote-unquote natural family or any kind of family they came from. I'd like to know whether there is a policy, whether there are measures to continue paying attention to the family the children came from, to strengthen their capacity to take care of the child themselves. Because it's always meant as a very specific measure. It separates children from their parents in general. And the question is, are all placements, whether in kinship care, in foster or in residential, a decision that is made by a court in order to at least check issues of best interest, to have the views of the child heard in this particular move of the child away from her or his parents to another place. So that is an additional question. Those are the questions, Mr. Minister. And I don't know whether you want to just start immediately or you need some particular break. But if you need it, let me know. You want a break? Okay. Okay, we take a break. We take the usual 10 minutes. So 10 minutes and 30 seconds.
Your answers if you are to be assigned to answer these questions. If you don't have to answer these questions, please go out and have a cup of coffee.
各位贵宾，在会议室外备有茶点，请各位享用。我们将在10分钟之后继续回来接续后续的审查会议。谢谢。